Hello, constitutional law students. This is a lecture on the material presented in Module 9 on due process. In this lecture, I will discuss the following topics: general principles of due process, some key features of substantive due process, and some key features of procedural due process. Have you ever wondered what the words due process actually means? In the American legal system, it means fair law. And America did not invent it. Our principles of due process were inherited from the early days of British rule. Even in the Magna Carta, the document written in 1215, British nobles forced King John to agree that he could not take away their life, liberty, or property except according to the law of the land. Our Constitution subscribes to that limitation. No government can deprive a person of his life, liberty, or property except according to laws that uphold basic fairness. We enshrine that principle quite specifically in two places of the U.S. Constitution. The Fifth Amendment prevents national government from abusing its powers. It provides that no person shall be deprived of life, liberty, or property without due process of law. The 14th Amendment prevents state governments from abusing their powers. It reads that nor shall any state deprive any person of life, liberty, or property without due process of law. Note that for both of those clauses, we are limiting government power. Due process only applies to governments, not or to state action, and not to the powers of private citizens or private businesses. We are looking, when we're talking about state action, remember we're talking about laws that a government passes, the actions of government employees, and also the times when government actually is controlling the discrimination that is sought by private organizations. And in this particular module in Chapter 9 of your textbook, the textbook gives some examples of what it calls entwinement of government actors and private organizations. There are certain circumstances where the degree of that entwinement can result in a finding that state action has occurred, that it's not just private discrimination. The rights of due process belong to a person, to individuals. It is not a perk of U.S. citizenship. If you notice above, both clauses use the word person, not citizen. And a person includes business organizations some of the time, but it always includes immigrants. You may recall learning that principle from our study of the U.S. Supreme Court decision, Yickwo versus Hopkins. There are two types of due process: substantive and procedural. Substantive due process prevents the government from doing something. The due process clauses in the Constitution prevent the government from interfering with certain freedoms. So you can consider substantive due process as a negative principle because it is denying the power of government to take some action. Procedural due process is a requirement of government to do something. It prescribes rules that governments must follow. So in that sense, it is a positive principle. It is requiring action by government. We're going to start by looking at just some of the key features of substantive due process. What are the freedoms that the government cannot infringe? What can it not do? Well, we start with the enumerated liberties. Historically, the substantive freedoms protected by the due process clauses were limited to those enumerated in the original articles of the Constitution or in an amendment to the Constitution, such as the liberties explicitly identified in the Bill of Rights. Those are the freedoms we're most familiar with. And by explicitly identifying them there in the Constitution, We have designated these liberties as fundamental to our freedom. And so courts are going to scrutinize any government effort to restrict those fundamental freedoms, the ones that we've enumerated. But there are also unenumerated freedoms, liberties that are not explicitly identified in the Constitution. The Ninth Amendment recognizes that those other rights exist, that there are other rights retained by the people, but it doesn't tell us how to determine what those other rights are. Well, they must be fundamental to freedom. In order to receive the protection of strict scrutiny, they have to be fundamental to our understanding of what it means to live in a free country, to be a free individual. And for that determination, the Supreme Court is often going to look to history and tradition. It's going to review the historical protections, if any, that have been afforded to a liberty in the common law as it existed when the Constitution was ratified. If a liberty is not fundamental, governments can restrict them, provided that two simple criteria are met. The law must first serve a legitimate interest. It must be reasonable or rationally related, or there must be a reasonable and rational relationship between the law and the stated interest. And the law cannot be arbitrarily applied. Let's look a little bit more at the unenumerated liberties, the ones that the Supreme Court has recognized so far. The first unenumerated liberties recognized by the Supreme Court were economic liberties. Our nation was founded on the philosophy of laissez-faire economics that allowed the pursuit of property and wealth unfettered by government interference. Economic liberty at the origin of our country really wasn't a great concern. But beginning in the late 1800s and early 1900s with the progressive movement, states began enacting laws to improve working conditions, to protect workers from exploitation, and to protect consumers from unsanitary food preparation. Businesses, not surprisingly, opposed those progressive laws. Now, these are, as I said, laws. They are legislation, and legislation by definition is state action. So the 14th Amendment does apply to these progressive era laws. And businesses argued that the legislation regulating their relationships with their employees and their own internal operations would violate the freedom to contract. The first time the Supreme Court recognized any such freedom was the case of Lochner versus New York, decided in 1905. Lochner versus New York involved a state of New York law, so the legislature of New York, influenced by progressive era policies, had imposed a limitation on the number of hours any person could work per day or per week. And this was part of a broad policy initiative to improve public health and safety. Mr. Lochner owned a bakery, and he and his employees had agreed to a longer workday. The state of New York fined Mr. Lochner for violating the labor law by allowing his employees to work these longer hours. And Mr. Lochner argued that the labor law violated the 14th Amendment by infringing upon a property right. And recall the 14th Amendment protects life, liberty, and property. So he identifies a property right, a right to contract with his employees. Although the 14th Amendment protects a person's life, liberty, and property, it doesn't specifically protect a freedom to contract. So the freedom to contract is not an enumerated civil liberty. But in Lochner, the court for the very first time recognizes that such a freedom is protected by the 14th Amendment's Due Process Clause. It agreed that states have the police power to enact laws that protect health and safety, but it held that in this case, the state's purpose of improving public health was not rationally related to the work hour restrictions. And so, what Lochner stands for then is the first time the Supreme Court has applied substantive due process to recognize an unenumerated civil liberty. It set that precedent, and the court has continued to use substantive due process, though in a variety of other contexts. And you should note that Lochner applied a slightly different test than is used today. The court first looked at whether the state of New York had a legitimate interest in improving public safety and health, and it did. It said yes to that question. However, the second question that it posed was whether that law was rationally related to the interest. So it was looking at the law specifically about bakeries and limitations on work hours, and they decided no, that sort of restriction really wasn't rationally related to its goal of public health and safety. We would probably disagree with that today, but that was the court's holding then in 1905. And it has changed quite a lot. As the textbook notes, the Supreme Court often upholds these types of public health and safety regulations of private businesses. But we should look at the other contexts now in which unenumerated liberties have been designated through substantive due process. They tend to involve now personal liberties. For example, the court has recognized the right to make parenting choices free from government interference, the right to work, the right to travel, the right to marry, and even the right to contraception. These are all considered rights that are fundamental to freedom. And these personal liberties fall underneath a larger umbrella that we often refer to as the right to privacy. You might also see it as the right to personal autonomy or simply the right to be left alone. We'll study these rights, these privacy rights, at a later module in the course. Substantive due process is also an issue in civil lawsuits involving private citizens. The courts presiding over such private lawsuits are called to enter monetary awards to successful plaintiffs. Sometimes those awards include an amount that exceeds the compensation actually due to the plaintiff for his or her injuries. The jury may find that the defendant should pay a sum of money to the plaintiff as punishment for more egregious conduct, such as intentional harm or gross negligence or recklessness. Those awards are called punitive damages because they are intended to punish the defendant. When a court enters a punitive damages verdict, it is depriving the defendant of property, of money. So substantive due process principles apply, and the Supreme Court has held that punitive damages awards, those verdicts, must be fair, and they must offer predictable consequences for this egregious conduct. They are making these determinations, these substantive due process determinations, on a case-by-case basis, and they'll consider the reprehensibility of the defendant's conduct and typical punitive damage awards in similar cases. A few states have even enacted statutes that place a fixed amount of a fixed maximum amount of punitive damages. Sometimes it's a ratio. And then in some cases, there are regulations that just simply guide the determination of what a damages award should look like. And I've just put up there a newspaper headline involving a rather notorious decision of a court involving punitive damages. You might Google that someday, the McDonald's coffee lawsuit and the huge punitive damages award that was given there. You might just find that interesting. Now we're going to shift to procedural due process. And just as a reminder, this is the due process type that is considered positive because it requires government to do something, to handle itself in a certain way. There are basic due process requirements that the Supreme Court recognizes in every situation. They include notice, a person's opportunity to defend himself or herself, a hearing before an impartial panel, whether it's a judge or a jury. Those are just the basic elements of due process. But there are more specific ones that have been recognized in the context of criminal prosecutions. And these are enumerated in the U.S. Constitution. We find them in the 4th, 5th, 6th, and 8th Amendments. As the Ninth Amendment expresses, the Bill of Rights is not the only source of criminal due process protection. So courts will apply the basic protections of due process and consider them in specific situations. And your textbook gives a few examples of those, such as in the case that's where you have an excerpt from the case of City of Chicago versus Morales from 1999. And that was a case involving an overly vague criminal law. And the Supreme Court found that overly vague criminal law failed to provide the basic requirement of notice, letting individuals know what is and is not criminal behavior. And in that Morales case, we're talking specifically about a loitering ordinance that the court found did not afford sufficient notice of when walking around a city would be considered criminal or innocent. Procedural due process actually extends past conviction and even to post-conviction proceedings such as parole hearings. You see an example of that provided in the textbook. Procedural due process now applies even in juvenile proceedings. Our current juvenile justice system is not considered the equivalent of the adult criminal justice system, although there are many parallels. And the development of the juvenile justice system rarely included consideration of a child's due process rights. It was not until the 1960s that the court first recognized that injustice. The landmark decision of N. Ray Galt in 1967 first held that at least some of the due process protections afforded to adults must also be afforded to children. Your textbook lists those due process protections and cites a few other cases. These are all important cases for you to learn now, as we will not have another opportunity to study due process in the context of juvenile justice. So pay close attention to those juvenile justice cases that are in your textbook and learn their significance. Procedural due process is applied also even in civil cases. Civil lawsuits are disputes between private citizens in which one party, a plaintiff, is seeking money damages and sometimes other forms of relief from a defendant. But civil lawsuits involve the court system. Plaintiffs are filing their lawsuits in a public court, and that court is going to apply procedures for the enforcement of the judgments. So state action is definitely present even in civil cases, even in private law cases. So at least to an extent, the 5th and 14th Amendment will apply. We already noted that substantive due process has been applied in civil lawsuits with respect to the amount of punitive damages a defendant may be required to pay. But procedural due process will also apply in civil lawsuits, though to a more limited extent than in criminal lawsuits. An example of an enumerated procedural due process requirement is the 7th Amendment's requirement that a jury be afforded to a defendant in a civil case. That only applies to federal courts. The 7th Amendment is one of those that has not been incorporated through the 14th Amendment and applicable to states. However, most states do give a right to a jury trial in civil lawsuits as well. So even though the 7th Amendment hasn't been incorporated, there is a right to a jury trial in most, if not every state of the U.S. But that's just, the 7th Amendment is just an example of an enumerated procedural due process requirement that applies in the context of civil cases. Now, beyond the 7th Amendment, Procedural due process is provided through the rules of civil procedure and common law decisions that have interpreted them. Those basic due process requirements of notice, opportunity to defend oneself, having a hearing, and an impartial jury, those are all kind of wrapped up into the rules of civil procedure and certain common law decisions. Let's look at notice first. Notice of a lawsuit is provided through something called the service of process. Typically, a person will hand deliver a summons and complaint to a person who is being sued. So they're delivering an actual document to the defendant. It's a summons from the court to appear attached to a complaint that describes the factual and legal basis of the claims and the amount and type of damages that are demanded. That gives this individual defendant the opportunity, so notice of the case, the opportunity to show up, to appear and defend him or herself against the lawsuit before an impartial judge and jury. Next, we look at personal jurisdiction. This was something we discussed in a prior module a bit. A court's power over an individual is the power to require that individual to appear and participate in a lawsuit, in a civil lawsuit. And it gets a little bit tricky. An individual must have sufficient minimum contacts with the state before its courts may assert personal jurisdiction over that individual. When a person or business is a citizen or resides in a particular state, minimum contacts are obvious. But what about non-residents, non-resident individuals, or non-resident business organizations? There has to be a factual analysis and determination that the individual's contacts with the state are sufficient to make it fair to hold him to be accountable in its courts. Courts are going to consider an individual's and even a business's activities within the state and whether those activities are sufficient to assert in personam jurisdiction over that non-resident. When a non-resident owns property within a state and that property is the subject of the lawsuit, a court will have in rem jurisdiction over the non-resident. That sometimes happens in title disputes. Due process protections are also afforded in rules governing the burden of proof. Now, in criminal cases, that burden is very high. We know it is the burden to prove a person's guilt beyond a reasonable doubt. So it's a really high burden, and that's because a person's very freedom, sometimes their very life, is at stake. In civil cases, where a person's freedom in life is not in jeopardy, the burden is somewhat lower. It is the burden to prove liability beyond by a preponderance of the evidence. In other words, the evidence is sufficient to say that the defendant, more likely than not, has offended the plaintiff and is liable to the plaintiff in some way. The burden of proof in civil cases can be a little higher under certain special circumstances, such as when the defendant may be subject to civil commitment in an institution, or when an individual stands to lose parental rights. In those situations, those specific narrow situations, sometimes the states require evidence to be clear and convincing. Sometimes even punitive damages awards, those facts have to be proven by clear and convincing evidence. So this is just another opportunity where basic fairness is afforded in the civil case with respect to a plaintiff's burden of proof. On a case-by-case basis, there are additional protections that may be given to indigent defendants. You probably are familiar with the right to counsel that is part of criminal due process. So if an individual cannot afford an attorney, then it is the obligation of the state to provide an attorney at the state's expense. There has been, in certain situations, that that burden is placed in civil cases as well. Sometimes the state is required to provide counsel to indigent defendants, even in civil cases. But again, these are just decided on a case-by-case basis. Procedural due process is also required of government agencies. So we're not talking necessarily about the main institutions of government, the executive and legislative and judicial branches, but rather the independent administrative agencies that are acting as kind of the implementation arm of the government. Government agencies are organizations that are formed by the president or Congress to implement the law. Most of them regulate business activity or provide government services of some sort. A well-known example of a government agency is the Department of Motor Vehicles, and that's why I've got that image on the screen to help you recognize what we mean by government agencies. But because they are implementing the law on behalf of Congress or on behalf of the president, their actions are considered state action. So the Fifth and 14th Amendment will apply to the activities of government agencies. The extent of due process protections, as they might apply to government agencies, is going to vary a good bit. The Supreme Court has just outlined certain factors that it considers when administrative agencies are being put on the hook for the Fifth and 14th Amendment. They're going to consider the nature of the individual's interests, whether it is truly a liberty or property interest that is at stake. They'll consider the risk of a bad decision, the erroneous deprivation of that liberty or property interest. And they'll look also at the burden. What type of burden is being placed on government agencies if this due process requirements are imposed upon them? Your textbook describes several types of situations where analysis of those three factors have been applied. I'm not going to go over them in this lecture because it's just a matter of reading what the textbook says. So you can see examples of how procedural due process has been applied in the context of government agency actions. That's all I have for this lecture. If you have any questions or concerns, feel free to call, email me, or come by and see me in my office.